प्यारे बच्चों, welcome to this online distance learning mode of Dharmashastra National Law University. Today we are again covering another topic, another part of the topic, that is maintenance under Hindu law. Today we'll be resuming from where we have left in the last class. I hope you are well and healthy at your homes, and please stay safe, and you must keep the process of learning continuous. So without wasting any time, let's begin with the discussion for today. I would recommend that you must open your bare acts, that if anything is required to be mentioned, I'll mention, and you can kindly see that in your bare act. Okay, thank you. Moving on to the next slide. Now, one question is very much fundamental when we discuss the rules regarding maintenance, is that what are the factors which determine the quantum of maintenance, means how much maintenance will be given. Section 24 and 25, they do clearly mention what are the circumstances in which maintenance should be given, but they are silent about the aspect that how much maintenance should be given. Although the section gives us a brief idea that the uh, conduct of the parties and the income of the petitioner respondents will be taken care of, but many other factors are also on in the play, as well as the judiciary have interpreted this section in a particular manner, and we must see this section 24 and 25 from the prism of from the prism of the judicial interpretation. So the judicial insight in this regarding will begin with the case law that we are going to discuss today. The first aspect, the first factor which determines the quantum of maintenance is the maintenance awarded under other statutes. I have told you that, and if a particular woman, if suppose wife is entitled to maintenance under various legislation, suppose she is entitled to maintenance under Hindu Marriage Act, as well as Hindu Adoption and Maintenance Act, as well as CRPC, as well as Domestic Violence Act, or any legislation she is entitled to maintenance, then those rights are independent and can coexist separately. There is no requirement that if you are claiming maintenance under one act, it will bar all the other remedies. In the last lecture, we were also discussing the same. So, but while determining the quantum of maintenance, that how much maintenance should be granted, the courts will keep in the mind the maintenance that has been already awarded to her under different legislation. In this case of Ashok Pal versus Manjulata, the factual situation was like this only, that the wife was getting a particular sum of money under uh, a legislation, that is Hindu Adoption and Maintenance Act, or suppose CRPC. Suppose CRPC she was getting maintenance, and again she filed a case under section 24 of Hindu Marriage Act, then what will be the correct position of law? So the court said uh, the in a case where she is already getting maintenance, that will although not extinguish her right to claim maintenance under Hindu Marriage Act, but certainly that will be a determining factor, that will be a very important factor while deciding the quantum of maintenance. Suppose court thinks that this woman 3000 rupees will be enough maintenance, and she's already getting 2000 rupees as maintenance under suppose 125 CRPC, then the court will grant her 1000 rupees more, or whatever that is needed, but the adjustment will be made. So this very much this must be kept in mind, that the adjustment can be made in that regard. Now the next point is means or capacity of non-applicant. It means, no, see, for the purpose of entire lecture, non-applicant is the person from whom the maintenance is claimed, and the applicant is the person who is claiming the maintenance. जो maintenance मांग रहा है वो applicant, और जिससे maintenance मांगा जा रहा है वो non-applicant. In the case of Atar Singh versus Jasoda, this is also a very important judgment, and interesting judgment to a sense also, that in this case court said very clearly that the actual means and capacity of the non-applicant, suppose in the case of husband, the presumed capability is also considered. It means that every able-bodied man, if a person is able-bodied, he is not physically or mentally sick, then it is presumed that he has means to earn property. A husband cannot go to the court of law and say, sir, I am unemployed, I am looking for a job, I am not getting job, there is too much population, the government is not providing me job, so I will not give maintenance. If a person is able-bodied, if a person is capable of earning, then the court will presume that he have means of earning. He will earn his living by doing anything. It is not required that the man should be doing something which is at par with his educational qualification. Suppose a husband is having a PhD and he wants to say, I have a PhD, I'll always teach as a professor of a university, but I'll take no other jobs, so I don't have any income. So the court will not accept that. The court will say that you can earn at, if you are able bodied, you can find a work. So we'll presume that you have found a work, you have earning. So your capacity to earn will simply be judged on the fact that whether you are of sound body and mind and capable of doing labor or not. That labor may be skilled, unskilled, manual, or white collar, blue collar, anything. The third aspect, income of the non-applicant, that is also very important. Income of the non-applicant means how much husband, as the case may be husband or wife under Hindu Marriage Act. Although this lecture, when we are discussing about maintenance, we are discussing these rules for determining quantum of maintenance is applicable to all the legislations, that is Hindu Adoption and Maintenance Act, CRPC, Hindu Marriage Act, and other secular laws also. The guidelines or the criteria of the courts are more or less very similar. So when we are determining the income of the non-applicant, we will take the net take away salary. Now the income a person gets, there are certain deductible amounts. Suppose that if I earn a particular sum of money, then I'll have to pay taxes. Suppose the husband is earning 50,000 rupees, he has to pay taxes. The company also direct provident fund, he has to pay the professional tax, he have to pay a number of things. Generally, there are standard deductions from the income of a person. Only he gets the salary after the deductions has been made by the company or the employer. This is the rule of Income Tax Act. So that net income shall be the criteria of accessing the amount that should be given as maintenance. मतलब कितना पैसा दिया जाएगा, ये ग्रॉस सैलरी पे आप डिटरमाइन नहीं करते हैं, या आप डिटरमाइन करते हैं नेट सैलरी पे जनरली. In this case of Rita Sharan versus Sharendra Sharma, the husband claimed, sir, my gross income is very high, but my net income is less. Now there are two types of deductions. ये भी ध्यान से समझिए. Some is compulsory deduction and some are voluntary deductions. जैसे कि सपोज मैंने LIC करा रखी है अपने नाम की 10,000 रुपए की, मेरे सैलरी अकाउंट में आती है, 10,000 रुपए मेरे LIC में कट जाते हैं. सपोज मैंने सिस्टमैटिक इन्वेस्टमेंट प्लान SIP ले रखा है. सपोज आई हैव इन्वेस्टेड मनी इन एनी रिकरिंग scheme of the banks. So in all these cases, those deductions which I suppose income premium or systematic investment plans or mutual funds, these are voluntary deductions. These deductions are made because I want these deductions to happen. Means अगर मैंने LIC खरीदी है तभी तो रिडक्शन होगा ना, अगर मैंने LIC नहीं खरीदी तो रिडक्शन नहीं होगा. So voluntary deductions are not considered. It means suppose the husband is earning 1 lakh rupees, 30,000 are compulsory deduction like income tax, professional tax, or any number of tax, provident fund, which are compulsory deducted from the salary, and he gets salary of 70,000, out of which 10,000 rupees is SIP and 10,000 rupees is insurance premium. So the maintenance shall be decided on the amount that has been ascertained after the compulsory deductions. Voluntary deductions are ignored. यानी आपने कितना पैसा इन्वेस्ट कर रखा है वो नहीं देखेगी सरकार या कोर्ट. जब मेंटेनेंस डिटरमाइन कर रही है, कोर्ट देखेगी कि आपको हाथ में कितना पैसा मिला, उसके बाद उसमें आपको आपने कहाँ इन्वेस्ट किया इससे कोई मतलब नहीं है. हाँ, बाकी जो कंपल्सरी डिडक्शन जैसा टैक्स जो है वो आपकी सेविंग तो है नहीं, वो दैट गोज टू द गवर्नमेंट. So simplest sense, The income of the non-applicant shall be determined after reducing the compulsory deductions. Compulsory deductions means payment of taxes or payment of provident fund that are compulsory to be given. Rest all deductions that are voluntary, suppose like investments, they are ignored for the purpose of awarding quantum, for determining quantum of maintenance. Now again another case is regarding SS Bindra vs Tarvinder Kaur, that is point of time of accessing of the income. This is also very technicality. ये भी एक technicality है. This says that a person, when we file a particular case, and of course you know that we have a snail paced judicial system is very slow and it takes time for a case to be decided. So what happened in this case, if you will read this case, you will find that the wife filed an application for maintenance pendentality under section 24 of Hindu Marriage Act, and she claimed 30,000 rupees per month plus 33,000 as litigation expense. She wanted that the husband must also pay the expenses that is incurred by her for defending herself in a matrimonial dispute. The trial court assessed the husband's income at 1,30,000 rupees per month and accordingly ordered him to pay 75,000 rupees per month plus rupees 1 lakh as litigation expense. The husband filed a case against that, said that she demanded even 30,000 and the court is giving her 70,000. What is this absurdity? Now, in this case, what happened? The principle that was recognized by the High Court is that the maintenance was awarded way back, and the court decided the quantum of income after suppose 5 years. You see, when the case was filed, the husband's income was different, and when the actual case was decided, when the maintenance was granted, the husband's income increased. So to freeze it, so to if we fix the amount of maintenance, that it will be unfair, very much unfair, because of course money, the purchasing power of money, the power of money to buy things reduce over the time. We have the principle of inflation. So suppose the case continues for 10 years, and suppose we discussed that in last class also, if the amount will be fixed and will not increase, then eventually it will create great hardship for the other party, the applicant in this case, जो maintenance मांग रहा है उसके लिए, it will create a huge problem. So in this case, court said that if your orders were to be pegged to a particular point of time, then if the income of the earning spouse were to suffer a drastic reduction for any reason, including deterioration in his or her health, the court will be precluded from making any adjustment to these factors. अच्छा, अब इसमें दो बातें आती हैं बच्चों, that if the income increases and suppose income decreases, then what happens? Suppose if the husband, suppose there is a matrimonial dispute and the husband retires from the job or becomes incapable of performing the job. So suppose his salary was 1 lakh rupees and he was supposed to pay 40,000 rupees to his wife, and immediately after the retirement his pension becomes 50,000. Now if you will expect 50 that out of 50,000 rupees he should pay 40,000 to the wife, that is absurd. So the court will make adjustment from the time to time. That is also the provision of section 24 that you must have read. So the point of assessing the income through which the factors determining the for which the determination of quantum of maintenance will be done is fluctuating. Time and again you will have to revise the maintenance, amount of maintenance, so as to keep in relevant to all the factors, relevant to the time as well. So moving on to the next slide. हाँ तो बच्चों, in this slide we are talking about income of the applicant. Now applicant's income is very much important here. Applicant's income means जो पैसे मांग रहे हैं, यानी जिसको मेंटेनेंस मिलना है, उसकी इनकम. In the previous slide we were discussing about the income of the non-applicant, यानी कि the person against whom the order of maintenance is sought. जिसको मेंटेनेंस देना है उसकी इनकम की बात कर रहे थे. अब हम बात कर रहे हैं उसकी इनकम की जिसको मेंटेनेंस लेना है. Apologies. Now there are certain cases regarding that. The first case being Indu Singh versus Ranjit Singh. Before that, we must know that while we're discussing section 24, we uh, talked about that when the spouse is not capable of supporting himself or herself. Now here, the word supporting and the word having sufficient means to support herself, it means that the income of the applicant, in order to deny the liability of maintenance, must be such that she can live properly and she can maintain a lifestyle that she would have got if she was to continue living with the other spouse. जैसे कि अगर पत्नी पति के साथ रह रही है, तो जिस लाइफस्टाइल में वो रह रही है, अगर वो शी इज सेपरेटेड फ्रॉम द हस्बैंड and she claims maintenance, if there is a matrimonial dispute and she claims maintenance, then the court will award such amount to her that will entitle her to get same amounts of luxury, same amount of comforts, same amount of lifestyle that she would have got if she stayed with the husband. यानी कि उसकी lifestyle को maintain रखा जाएगा. Now income of the applicant is a very important factor, and if a wife does not have a recurring or a permanent source of income, if she has any fixed asset that is immaterial, that we discussed in the last class also. In this case, Indu Singh and Ranjit Singh, the fact was very simple that in this case the wife had some gold. So what did she did? She sold the gold, वो गहने बेच करके, and the amount she got, she deposited in a bank as a fixed deposit, and she was surviving of the interest of the amount that came. So the husband says, sir, my wife had gold and she has a fixed deposit. She's earning the interest of that money and she has this fixed deposit. The court says that is irrelevant factor. That will not be considered income within the meaning of section 24. If she is earning by selling her ornaments, that is not the income that we are talking about. जो अपने गहने बेच करके चल रही है काम, तो हम लोग कहेंगे कि सर उसके पास इनकम है. तो दिस इस केस में कोर्ट ने बहुत क्लियरली कह दिया. In the case of Prem Kumari versus Om Prakash, the wife was earning a meager amount of money because she was doing tuitions. वो tuition पढ़ाती थी wife, and the wife was teaching tuition even when they were living together, and she earned some amount of money. Now after they were separated, wife continued to teach tuition and she was getting a certain sum of money from the students that she was teaching home tuitions. Of course आप कई जगहों पर देखा होगा आपने कि कोई महिला घर पे कुछ बच्चों को बुला करके पढ़ाती हैं. So the court said that if the amount that is earned by her is not significant, it means that her lifestyle would suffer if she is left alone with her only tuition income. यानी सपोज उसका हस्बैंड 50,000 रुपए कमाता था and the wife earned 10,000 more by doing tuitions and she's living separately, then she has suppose out of 50,000, 25,000 rupees was spent on her. So and she earned 10,000 rupees more. So her lifestyle was about 35,000 rupees. उसके lifestyle 35,000 रुपए तक की थी. But if she is separated from the husband, her lifestyle would diminish. उसके पास necessary चीजों को fulfill करने के अलावा कुछ नहीं बचेगा. तो उसने कहा कि we are not talking about necessities here. We are talking about maintaining the same lifestyle if this need of providing maintenance would not have arisen. So the court said that even if she is earning a meager amount of money that would be sufficient for survival, that is not the question. The question is that if whether the income that she is earning is sufficient for her to maintain the same lifestyle कि अगर वो अपने husband से अलग नहीं रह रही होती तो. So this was the case in this regard. In a similar case, that Sangamitra Singh versus Kailash Chandra Singh, the wife was earning some 1400 rupees and the husband was earning 7,000. Now again the court said that there is a disparity between the income. Disparity between the income of the husband and disparity to the income of the wife. So the court said that the husband will have to give as much money as to the wife so as to make a parity between their income. अब यहाँ पे खास बात समझिए, यहाँ पे इक्वालिटी ऑफ इनकम की बात हो रही है, यानी कि अगर हस्बैंड ज्यादा पैसे कमा रहे हैं, वाइफ कम पैसे कमा रही है, पर वाइफ पैसे कमा रही है, तो कोर्ट इतना मेंटेनेंस देगी वाइफ को ताकि उन दोनों के बीच के इनकम के बीच में पैरिटी हो जाए। तो सपोज जैसे कि 1 लाख रुपए हस्बैंड कमा रहा है, वाइफ कुछ भी नहीं कमा रही है, तो कोर्ट कहेगी आधे पैसे वाइफ को दे दो, या अगर बच्चे हैं तो आधे से ज्यादा दे दो। तो दिस विल ऑल बी द फैक्टर कि पैरिटी आना चाहते हैं हम लाइफस्टाइल में। If the husband and wife are living separately, then in order to bring parity to their income, the court will award maintenance. Ab husband is earning suppose 1,000 rupees a month, so wife will get only 500, so as to make a parity. The wife will not be given more money, so as to husband will have to starve and all the money will go to wife, but a parity should be made, equality should be there. Acha, in another case, if the wife, this case we read in the last lecture also, Manokarna versus Devki. This is also a very interesting case, but the facts of this case were not discussed. And now we'll discuss that. In this case, what happened? The wife was employed in a hospital. She was earning suppose 4,500 rupees per month. This case is of older times. Suppose 70s का case है, शायद 80s का case है. And she was earning 4,500 rupees working in a hospital, and the husband was earning a meager 70 rupees a day. Husband था कहीं पे labor and he was earning 70 rupees a day, and the wife was earning 4,500 rupees. In this case, court said that here the wife's income is more than husband. Now, since the husband is able-bodied, he cannot claim maintenance from the wife. But here, wife also can't claim from maintenance from the husband because there is already wife is in a superior position. Wife की income ज़्यादा है, husband की income कम है. So already the question, the balance of parity is in the favor of the wife, already in the favor of the women. Now again, this provision, although is made gender neutral, the importance of this section is to protect the rights of the wife. All the laws that we have generally, because these patriarchal setup are not very much in favor of the women, so the laws are made in such a manner that it will favor the women. Article 15 clause 3, you know, of course. So in this case also, court said that because wife is earning way more than the husband, she has means, sufficient means to maintain herself, and the husband has no means to further starve himself and make the luxurious life for the wife, so it is not required. The court said no maintenance is supposed to be awarded in this case. Now, bachcho, this is the two aspects we have discussed today. In the next lecture, we'll discuss some more important points that are required to be understood in this context. There is a conflict in the minds of judiciary. Different high courts have very contrasting opinion on some of the aspect of this particular topic that we'll discuss in the next lecture. And there is progressive trend as well in this regard. So we'll discuss all this in the next class. For now, I have given you my phone number. There are two email IDs, familydnlu@gmail.com. This email ID is for the purpose of mailing your answer script of the class test, and animesh@mpdnlu is for submission of projects. So kindly submit of the projects as soon as you can. At least before the beginning of the college, you must submit your projects, and after you come we'll have the presentation. So don't panic, whatever time will take, but things will be adjusted. So keep on studying, kindly read the bare act once again, and I'll see you in the next lecture with this topic continued.